You know, when we talk about our legacy, we usually think about memories and the people we love. But have you ever thought about the afterlife of your assets? Every single thing you own is about to go on a journey. And the real question is, are you the one who's drawing the map?
Because here's a little secret, you already have an estate plan. Yep, right now. Whether you've made one or not, it exists. The only question is it the one you actually want?
That's right. If you don't create your own plan, the state has a default one just waiting in the wings. And let me tell you, it probably looks nothing like what you would have picked for yourself.
And the difference between your plan and the state's? It's night and day. Your plan is personal. It's about your wishes for your people, and it's all handled privately. The state's plan? Well, that's a rigid, one-size-fits-all formula. It's totally impersonal, and the whole thing becomes a public court record that anyone can go and look up.
A really thoughtful plan can be this final, powerful act of care. I mean, just look at what David Bowie did. His plan wasn't just about shuffling money around. He set up a trust to manage assets for his wife, made sure his kids got specific gifts, and he even took care of his longtime nanny and his assistant. He even spelled out exactly what he wanted for his final arrangements in Bali. Now that's a legacy with real intention. So how does all of this actually work? Well, I want you to picture a fork in the road. Every single thing you own, your house, your car, your bank account, is going to travel down one of two very, very different paths. Path number one is the automatic non-probate path, and path number two is the court-supervised probate path. All right, let's start with that first path. Think of it as the non-probate superhighway. This is the fast lane. It's designed to get assets where they're going quickly, quietly, and completely outside of the court system. So, who gets to ride on this superhighway? Well, it's for any asset that has a pre-programmed destination. We're talking about things like jointly owned property with a right of survivorship, life insurance policies, those POD or TOD accounts at your bank, and anything you've placed inside a living trust. So, for example, take a house or a bank account that you own with someone as joint tenants with right of survivorship. It's like a built-in inheritance trigger. As soon as one owner passes away, their ownership just evaporates, and the other owner automatically absorbs it. Instantly. No court, no paperwork, no fuss. And then you've got your POD and TOD accounts. That's pay on death or transfer on death. These are just simple instructions you give your bank or your broker. You fill out a form, name a person, and when you pass away, that person gets the money. It is one of the easiest and most powerful tools you can use. Okay, but this brings us to a huge, critical question. Let's say you named your ex-spouse on your 401k a decade ago. Now you're remarried, and your new will clearly says, I give everything I own to my new spouse. That takes care of the 401k, right? It goes to your new spouse. No, it does not. And this is, without a doubt, one of the biggest and most heartbreaking mistakes people make. Here's the deal, and you really need to hear this. That beneficiary form you filled out, it's a legal contract. It's a separate document that completely overrides your will. Your will has zero power over these non-probate assets. It's a trap for the unwary, for sure. The will just doesn't control them. So in our example, your ex is getting that 401k. So what happens to everything else? All the assets that didn't have a ticket for the superhighway? Well, they take the other route, the probate detour. This is the official court-supervised process, and on this road, your will is the roadmap. This probate path is specifically for property that you own in your name alone. And on this journey, your will takes center stage. The person you name as your personal representative, sometimes called an executor, is the driver, and they're in charge of following your will's instructions, all while a judge looks over their shoulder. But hang on, what about the stuff you just forgot to list in your will? Or that piece of art you bought after you signed it? Does that just fall through the cracks and go to the state? Well, not if your will has a very important safety net built in. And for this, we can take a page from Marilyn Monroe's will. Look at this incredibly powerful legal phrase. All the rest, residue and remainder of my estate. This one little sentence is designed to catch absolutely everything. That is the magic of the residuary clause. It is the ultimate catch-all. It's a safety net that makes sure any property, not specifically given away somewhere else, any forgotten bank accounts, any future assets, it all gets distributed according to your wishes, not the state's default rules. It's so important. Now, even on this slower probate path, the law understands that a family that's grieving needs some immediate help. So it actually builds in some special protections to shield certain assets from creditors, making sure your family isn't left high and dry while the estate gets sorted out. Take Florida, for example. The law sets aside what's called a family allowance of up to $18,000. This is cash that goes directly to the surviving spouse or kids to cover basic living expenses. We're talking groceries, utility bills, during those first few tough months. It's a critical financial cushion. And another huge protection is called homestead. It's all about keeping a roof over the family's head. The logic is actually pretty simple. First, the court asks, is there a surviving spouse or a minor child? If the answer is yes, then the family home is totally shielded from most creditors and passes directly to them. If the answer is no, then the house is just another asset that can be used to pay off debts. Okay, so we've traveled down the superhighway and we've taken the detour. What are the big takeaways here? What do you really need to remember from all this? Well, when you put the two paths side by side, it's pretty eye-opening. The non-probate path is immediate, it costs little to nothing, and it's completely private. The probate path, on the other hand, well, it can easily take 4 months to a year. It comes with court costs and lawyers' fees, and it creates a public record of your finances. The benefits of planning ahead really couldn't be clearer. Look, if you remember nothing else, please burn these 3 rules into your brain. First, understand which of your assets are probate and which are non-probate. Second, and this is the big one, your will cannot, I repeat, cannot change a beneficiary on one of those non-probate accounts. And third, anytime you have a major life event, you get married, divorced, have a baby, you have to review everything, not just your will, but all those beneficiary forms too. In the end, your will tells a big part of the story of your legacy. But for so many of your most valuable assets, it's those little beneficiary forms that get to write the final, unchangeable chapter. So let me just leave you with this question. Are they telling the story you actually intend?